The saga of which I speak has to do with the National Park Service and various other government agencies and their Twitter accounts. And the reason I say it harkens back to the Biden-Obama memes is I can just see one of those crafted that goes along the lines of nobody expects the National Park Service being said by Joe Biden and Barack Obama rejoining Joe because the National Park Service sort of kicked things off a week ago, or maybe it was a week ago tomorrow, that account posted the now sort of infamous photo comparison of inauguration attendance on the one hand from a Barack Obama inauguration and inauguration attendance from the inauguration a week ago today. The pictorial evidence of which seemed to suggest a far smaller attendance at last week's inauguration than some others in the past. And the strange thing about this is the fact that it does not seem that the current administration anticipated or gave much thought to the fact that various government agencies have their own Twitter accounts, and those Twitter accounts are accessible by various government employees who may have opinions that they want to express via Twitter, or facts that they want to express via Twitter that might not be completely on message with the new administration. And we have been seeing that unfold over the last week with various tweets by various official government accounts, including the one I just mentioned, another one, for example, from the Badlands National Park on various climate change data. And here's one from Death Valley National Park as well, posting a picture of an individual who had been interned during World War II in a Japanese internment camp. So some of the messaging coming out of these official accounts has not exactly been what the current administration would vet and approve of had they the opportunity to do that. And then there has been this discussion of a quote unquote gag order, of which the White House has denied and said, no, we have not made any official statements or restrictions on government employees. And we'll get into that in a moment and what's going on there. But just to sort of complete setting the stage here, in the wake of some perhaps agency-imposed restrictions on these accounts, a slew of unofficial alternative accounts have sprung up that, as we sit here today, we really don't know. We can't say with any masterful certainty that they are being authored by people who are current or former employees of these agencies, but that is what they purport to be. Some folks have done journalism digging deeper on that, trying to see if they can answer questions that only folks in those positions would be able to answer. But as we sit here right now, it's difficult to say whether those accounts are legitimate or maybe something more along the lines of the sarcastic Rover or fake Steve Jobs, something that is cleverly doing commentary, but perhaps not what it purports to be. So this is the situation in which we find ourselves with these social media accounts of various government agencies. And I suspect, David, that you've been finding this situation as it unfolds quite interesting.
Yes, it is quite interesting. I mean, I think it's interesting. I was just preparing yesterday, and I'm teaching a First Amendment class this semester, and I was just preparing to teach the government speech doctrine and going over, restrictions on employee speech, and it was wow, I was being handed a law school hypothetical by the real world. So it has been very interesting. I think we're a little bit handicapped here because we don't know exactly what happened, and we are actually dealing in hypotheticals. Sometimes we hear there's not an official gag order. There's There's sort of an unofficial gag order. Sometimes we hear this is no different than what happens during any other transition where agencies are told to not issue policy pronouncements until the new administration is in place, and that's not typically a controversial thing. But I think the alternative, and then you had all these alternative Twitter feeds going up, and some of them were using logos, which is potentially violating federal statute. So there was a ton of interesting issues, and in some ways the alternative Twitter feeds were a great example of civil disobedience that the internet enables.
Right.
Could you unpack some of the government speech issues that you were preparing for your class tomorrow? I think some of our listeners would like a little background, I guess, on why, for example, using logos might be problematic for them.
Yeah, well, the logos is a little bit of a different issue because there's a statute, a federal statute that governs the use of logos. So it's not even really operating out of we're not even looking at normal trademark considerations or something like that, where you would look at whether or not people are actually confused by it or things like that. And that statute has generally been upheld that just using the logo. Well, I shouldn't say that. It just hasn't actually been tested that much. But that it would seem like to be like an unnecessary risk for someone who is otherwise clearly using having an alternative feed, or the name of the feed would be alt, Park Service or whatever. It's an unnecessary risk for them to take, and I think most of them now have actually stopped using the official logos. So,
I'm sorry. Sorry, I was just going to throw this out there as a question to you. In my sort of research into this, obviously it seems like it runs near issues related to whistleblowing, but also perhaps implicates the Hatch Act. Do you want to unpack any of that or elaborate on? Obviously, there's a lot of these Twitter accounts that are one of the things that people are saying is that these alt Twitter accounts should verify themselves somehow, either with third parties or with some sort of trusted third party like the ACLU or the EFF or someone, so that we don't know that so that we have some sort of assurance that these are actually people from within the organizations. And I know that I think that because some of these accounts are using the official logos of the organizations, there's particular concern that they would be running afoul of the Hatch Act. Do you want to elaborate into any of that or provide a little more expertise than I can provide?
Yeah, I mean, I'm certainly not an expert on the Hatch Act. In fact, I'm really far from an expert on the Hatch Act. But I as a lawyer, I would advise them just don't use the logo. I mean, you're not trying to pretend that you're the official feed, and I think most of them have stopped doing that now. And whether that's a use of government resources for an improper private purpose, that's an interesting question that hopefully we won't have to answer. I do think, though, that an argument that I was hearing, which is sort of related to the Hatch Act issue, is whether it's proper for the government employees to use the knowledge they've gained as being public employees, to use that for private purposes, for their own rogue Twitter feeds. And I think the First Amendment law there is pretty clear that is proper, that is protected. Right. And that was the last time the Supreme Court sort of jumped into the government employee speech doctrine. That's what it said. It distinguished speaking you do as a government employee because it's your job to speak in that way from speaking that you do that's not necessarily part of your job duties, but you're speaking because you have the knowledge as a governmental employee, and they found that the latter was protected speech. It is not, the restrictions would have to be subject to, to strict scrutiny as opposed to the very permissive standard for government employee speech.
Is there any differentiation to be made here, David, between the accounts that may be under a quote unquote gag order here, the official accounts, the ones that actually belong to National Park Services and the EPA? Is there any argument to be made by or on behalf of those government employees from a First Amendment standpoint that they should be allowed to have a little bit more latitude on the official government Twitter accounts, or as Emory alluded to a moment ago, is really the more appropriate law that we should be looking at there, perhaps whistleblower law.
Yeah. Well, I think, the problem with whistleblower law is that whistleblower law is its chief protections are to the disclosure of unlawful conduct. And and what we have here is really just what they're saying is we're actually putting out truthful information that we think might be counter to the new administration's policy. So I don't know that whistleblower law would protect the specific things I've seen. It doesn't seem like the purpose of these is to disclose unlawful conduct, and that's the chief protection there. In terms of whether or not the government could gag them from tweeting if tweeting was part of their jobs, the answer there is probably yes. Is that they can. And that would seem to be the more typical type of employee speech, government employee speech restriction, where there you're actually speaking for the government, you're speaking as a government employee, your speech bears the government imprimatur. These are all the types of things we use to talk about why government can control the message. It's its message. It's the government's message. And when people are speaking on behalf of the government can tell them what they can and cannot say. And so I think if it's someone's job to tweet for the government through the official account, then that I think the government has the ability, it would have the ability to restrict that.